Thank you, Representative Weissman. The House will come to order. The pledge this morning will be led by our very own Representative Mike Weissman.
Apparently, I'm not used to doing this. Okay, members, please join me in the pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Mr. Gregorio, please call the roll.
Representatives Amabile, Arndt, Bacon, Baisley, Benavidez, Representative Benavidez, Burnett, Byrd, Bockenfeld, Bradfield, Caraveo, Carver, Catlin, Cutter, Doherty, Duran, Representative Duran, Escar, Exum, Froelich, Geithner, Gonzalez Gutierrez, Gray, Hanks, Harrod, Holtorf, Hooten, Representative Hooten is excused, Jackson, Judah, Kennedy, Kipp, Representative Kipp is excused, Larson, Montine, Luck, Lynch, McCluskey, McCormick, McKean. Representative McLaughlin is excused. Michelson Janae, Mullica, Neville, Ortiz, Pelton, Pico, Ransom, Rich, Ricks, Roberts, Representative Roberts. Representative Roberts is excused. Sandridge, Sirota, Snyder, Soper, Sullivan, Tipper, Titone, Valdez A, Valdez D, Van Weber, Van Winkle, Weissman, Will, Williams, Woodrow, Woog, Young, and Mr. Speaker.
With 62 present, 3 excused, we have a quorum. Representative Burnett.
Mr. Speaker, I move that the Journal of Friday, February 26, 2021 be approved as corrected by the Chief Clerk.
You have heard the motion that the journal be approved as corrected by the Chief Clerk. All those in favor say aye. Aye. All those opposed, no. No. The ayes have it. The motion is adopted. Announcements and introductions. Representative Arndt. And before we move on, members, announcements and introductions, let's please keep the noise to a minimum and give our attention to Representative Arndt.
Thank you very much. Good morning, colleagues. Today is a very special day in the history of the United States Peace Corps, of which I was a member. And we have a small tribute that we'd like to have read.
State of Colorado, House of Representatives, convened in the 73rd General Assembly, hereby extends sincere commendations to the Peace Corps' 60th anniversary. 60 years ago this week, our nation launched an effort that would forever change the way Americans see the world and the way the world sees us. This week, our nation pays tribute to the more than 240,000 men and women who have served in 142 countries around the world in the United States Peace Corps, with 3,900 Coloradans answering this call to service since 1961. These Americans embody our country's finest tradition of service, fostering hope, goodwill, and friendship in the farthest corners of the world. A year ago, more than 7,000 Americans, including 220 Coloradans, were serving in the Peace Corps when operations were temporarily halted due to the COVID-19 pandemic. Many Americans are willing to step up to serve once again as soon as the program restarts, eager to help people help themselves in the spirit of sustainable and responsible development. The members of the Colorado House of Representatives commend and congratulate the Peace Corps for 60 years of encouraging progress, creating opportunity, and fostering mutual respect and understanding throughout the world. On request of Representatives Jenny Arndt and Chris Kennedy, given this first day of March 2021, State Capitol.
Thank you, Mr. Gregorio. Representative Kennedy.
Thank you, Mr. Speaker. Members, feel free to be seated. Thank you so much for standing for this tribute today. So, contrary to my colleague here, I actually did not serve in the Peace Corps, and so I'm here primarily because constituents of mine who feel really strongly about this have reached out and asked me to join in this tribute. I did have a close friend back in my old engineering days who left our engineering job to go join the Peace Corps and serve for 2 years in Suriname and had this amazing life experience that I always envied. And what he has really turned that into a lifetime of service. And so I'm just inspired by what I've seen and learned about the Peace Corps from those who have joined it, and I'm more than honored to help honor them on their 60th anniversary today.
Thank you, Representative Kennedy. Representative Arndt.
Thank you, Representative Kennedy, and thank you for the members, former members of the Peace Corps here. And I'm proud to stand here with Representative Kennedy because the Peace Corps is an idea, right? It's a concept. Some people serve in the Peace Corps, some don't, but that doesn't mean it's not an inclusive of the idea of service, commitment to our world, and recognition of other people, right? So that's why I'm so proud to have served in the Peace Corps Morocco from 1990 to 1992. I was also evacuated due to the Gulf War, working one day fully in Arabic and teaching at a small school for girls in rural Morocco, and the next day being home, was plucked out, and they take your passport away from you because it's a diplomatic passport, and then you can't apply for unemployment because you weren't employed, you were a volunteer. And I landed at my mother-in-law's house in McLean, Virginia. I went to buy a pair of jeans at the Gap, and they said help wanted. I started working at the Gap the next day. So 3 days before, I was speaking Arabic and teaching in the Peace Corps, and 3 days later, I was saying, hi, welcome to the Gap. And that was quite a surprise. So I can only empathize with everyone else who got evacuated last year due to COVID. And I'd also like to recognize the people who are here who served in the Peace Corps. And it's been going since the 1960s. So we have something in the Peace Corps, I'll be very brief, it's called the third goal. The third goal of the Peace Corps is what you bring home with you. And what we bring home with us is goodwill, service, and appreciation of people who think differently from us, who live different lives from us, speak different languages, practice different religions. And I sincerely hope that we can all extend that with the idea of the Peace Corps in our hearts. Thank you.
Thank you, Representative Arndt. Further announcements and introductions. Representative Byrd.
House Finance Committee, we are meeting today at 1:30 in Committee Room 112 in the basement. We will be hearing House Bill 1126, Senate Bill 019, and House Bill 1061. See you there.
Representative Pelton. And Representative Valdez.
Thank you, Mr. Chair.
Speaker.
Thank you, Mr. Speaker. I apologize.
You got it. Representative D. Valdez.
Thank you. And thank you, members. I just want to come down here and welcome everyone tomorrow morning at 7 a.m. down in the basement. Want to thank my colleague, Representative Pelton, for continuing to bring forth, because we need prayer not only every day, but we need to continue praying. So with that, we ask for you to join us.
Representative Pelton.
Thank you, Mr. Speaker. And just to echo what my colleague Dan File has been coming to this Capitol for several years doing the Capitol Commission. It's a good time to come fellowship with fellow believers, get something to eat and some coffee. 7:15 in the basement. We've been doing 109, but look for us down there. Thank you.
Thank you.
Thank you, gentlemen. Representative Kennedy.
Thank you, Mr. Speaker. Members of the House State Civic, Military, and Veterans Affairs Committee, we are meeting at 1:30 today to hear House Bill 1106, and we will not be in our normal meeting room. We'll be in the Old State Library, aka room 271. Thanks.
Thank you. Representative Madam Speaker Pro Tem Benavides.
Thank you, Mr. Speaker. Members, I want to take a minute to recognize someone from Colorado, and I asked some members of some of the caucuses to join us. There was a story in Saturday's newspaper about this woman. And so if I could have your attention, this is about the contributions of an unsung hero in our community. I could have done this last week during Black History Month, but this hero is Black, and she is a woman. And so I think today is also fitting because it's the first day of Women's History Month. Zipporah Parks Hammond, or Mrs. Hammond, as I knew her, would have been 97 years old today. She passed on in 2011. In 1946, Mrs. Hammond became the first Black woman to receive a Bachelor of Science degree from the University of Colorado School of Nursing. She was the only African American student in her class of 30 nursing students. But she was the only student who was barred from living on campus. She was the only student who was barred from studying with the other students. And she was the only student barred from any hands-on training in her field. But despite these obstacles, she proved more than capable of meeting the high standards of the nursing school. After graduating at age 22, Mrs. Hammond joined the Women's Cadet Nurses Corps. She was the only Black student nurse out of 1,600 who trained in Colorado to serve and care for the Army's Black troops. So she was also a veteran. Later, she was recruited to be the chief surgical nurse at the Tuskegee Institute in Alabama. She was asked to go there to care for children suffering from polio. Some of you may not know about polio and maybe didn't have to get the shot like me and some of the other members here did. But Black children who had polio could not receive treatment at the other hospitals. So it was important to have a nurse that could treat them. Mrs. Hammond later contracted tuberculosis and had to return to Denver, and she got cared for 2 years at the National Jewish Hospital. But in 1951, Mrs. Hammond obtained her medical records librarian certification and became Colorado's first Black director of medical records at what is now Presbyterian St. Luke's Hospital. Mrs. Hammond was raising her family, but still found time to volunteer for 17 years at the Denver Public Library, documenting photographs and articles that preserved Black history in Colorado. She also donated thousands of dollars on her modest income to more than 24 charities, including The Gathering Place, that serves women, children, and transgender individuals experiencing poverty and homelessness. I met Mrs. Hammond many years ago through her sons, Stephen and Daryl, who were classmates of ours, of me and my siblings at Manual High School. Her children will be submitting a nomination for her entry into the Colorado Women's Hall of Fame later this year. And I will be preparing a letter of support for her nomination. And I will ask all of you as members, particularly the Latino, Black, Women's, and Veterans Caucuses, to join me in that nomination letter of support. You know, I didn't know these things about Mrs. Hammond until recently, because true heroes are not singing their own praises. When Mrs. Hammond received the Living Legend Award in 2009 by her peers of Black women, they wrote, and I thought this was important for all of us, they wrote, "You make us walk taller, smile wider, dream bigger. You change the world with fierce determination, effortless style, unshakable grace. Thank you, Mrs. Hammond, for showing us how to fly by flying." I spoke to her son yesterday, and they couldn't be here. Her son Steve lives in Virginia, is retired and lives in Virginia. Her son Daryl and his family live in Longmont. So members, please join me in a round of applause for well, before I do that, I know other members wanted to say something. So.
Representative Herod.
Thank you, Mr. Speaker, and I'll be brief. I just want to thank my colleague from Adams County for bringing this to the chamber and to bringing it to the Black Caucus members. Specifically, Ms. Hammond is a jewel and continues to be a jewel and a legend in Northeast Denver. We do sing her praises and we do stand on her shoulders. She has countlessly given back to the community, not only in the work that she's done mentoring young people, but in her legacy to show us how we can be and how we can achieve. I also want to acknowledge the fact that my alma mater, CU Boulder, has had a very interesting history when it comes to race, a troublesome history. And they are going through a process of acknowledging some of the things that they have done wrong, including not allowing Mrs. Hammond to walk across the stage to get her degree, and others. And so I want to acknowledge and thank the University of Colorado for taking this step forward, for also working to increase the number of Black physicians as well through a scholarship named in the honor of our first Black doctor who has graduated from there. And I look forward to hearing conversations from other universities who are doing the really tough work as well. I've heard some great things happening across the state, and I look forward to members bringing that to the chamber as well. So thank you, Representative Benavidez, for bringing this forward. On behalf of the Black Caucus, we definitely appreciate it. We appreciate you, and we will definitely be a sign-on on that letter.
Thank you. Representative Benavidez.
Members, with that, please join me in a round of applause for the contributions of Zechariah Hammond. Thank you, members.
Thank you. Any further announcements or introductions? Seeing none, the next order of business is general order, second reading of bills. Representative Kennedy.
Thank you, Mr. Speaker. I move the House now resolve itself into the committee of the whole for consideration of general orders.
You have heard the motion. If there is no objection, Representative Kennedy will take the chair.
The committee will come to order. With your unanimous consent, the bills will be read by title unless there is a request for reading a bill at length. Committee reports are printed and in your bill folders. Floor amendments will be shown on the screen and on your iPads. Bills will be laid over upon the motion of the majority leader, and the coat rule is relaxed. Mr. Gregorio, please read the title of House Bill 1083.
House Bill 21-1083 by Representative Benavides, also Senators Priola and Zenzinger, concerning the modification on appeal of property valuation set by the County Board of Equalization.
Representative Benavides.
Thank you, Mr. Chair. And members, I move House Bill 21-1083.
Members, I know that's on second reading, so we do have side conversations at times, but it's already a little loud in here, so I'd ask you to please keep it a little quieter or step off the floor to have conversations. Representative Benavides, to the bill.
Thank you, Mr. Chair. Members, this bill was heard in Transportation and Local Government. It was brought to me by the assessors that right now, when someone has a protest about their property tax assessment, they generally take it first to the county. If they're still not happy, they go to the Board of Assessment Appeals. The Board of Assessment Appeals has the right to hear these cases based on de novo appeals. De novo appeal, which means they can look at anything. Based on that, though, they are limited in the actions they can take. By statute, they can only accept the assessment rate that the county has placed on the property, or they can reduce it. If they receive evidence that the property was undervalued, they're not able to increase the value. So all this bill is about is a matter of fairness. It takes that portion of one sentence out of the statute so that the Board of Assessment Appeals can raise the rate if that's the evidence they see. So members, we heard in committee some concerns from primarily commercial property owners that this would cause a chilling effect. It doesn't cause a chilling effect because, in effect, any commercial property over 15,000, which is almost all, which was admitted to at the hearing, is they are required to have an attorney. So they are getting professional advice on that. There's a limited number in Denver. The number of residential appeals is 0.04%. In 2019, it was 3 of those. In Douglas County, it was 0.2%, only 7 of those. So that said, I would urge a yes vote on this.
Is there any further discussion? Mr. Minority Leader McKean.
Thank you very much, Mr. Chair. And I actually have a question. So I've been through this process a couple of times, and I know that there have always been guardrails around it to say that, you know, if I protest and bring my own valuations, to have them taken a look at in that de novo setting. And so is that process still in place under this? And then what is the notification requirement out of that back to me? I know I get a postcard in the mail, but we sort of live outside of that world now. So what is the notification on the backside?
Representative Benavides.
Thank you, Mr. Chair. And just to clarify, the postcard piece and the letter, those are from the county. And that's what you're talking about. This has no changes to the county process. If you disagree, then you go through the county's process and you get notice when you get that of the timeframes with regard to that. It's after you go through that whole process at the county level. If you're still uncomfortable and want to protest further, you pay the tax, so the tax is already paid, and then you can appeal to the Board of Assessment Appeals. And for those of you that don't know, it's in the Division of Housing in the Department of Local Affairs. So it doesn't impact what you're describing.
Representative McKean.
Thank you very much, Mr. Chair. Thank you for that answer, because I really was confused about kind of where this lay. And then what I would ask is, then where's that hearing held? I mean, especially these days, do we have any structure around that? How do people get there? How do people make their voices heard within that setting?
Representative Benavides.
Yeah, those are set and determined by rule. They actually have a new system that they put online about 4 months ago, 5 months ago maybe, and those are scheduled, and everybody is notified. Right now, they're almost all by Zoom. But before, they held them at their DOLA's offices, I think, or some other location, but everybody got notice, and none of that changes. All of that still is the same, and everybody gets notice, and this doesn't change any part of that process.
Representative Bockenfeld.
Thank you. It's an honor to serve with you, Mr. Chair.
It's an honor to serve with you as well.
Representative Benavides, when I read this law, I believe that the original provisions put in there to where the Board of Assessment could not raise the value was to protect people, that we want to encourage, if they don't feel the value of their property is proper, that they will appeal it. And don't we have some fear that if we go to the Board of Assessment and they now can raise the value, that we have people that will be fearful of retribution because they're fighting their property tax value?
Representative Benavides.
Generally, these kinds of questions are raised in committee, but since you've asked, I will certainly attempt to give you a response. Is that no, that is not a problem because, again, there's two types of property assessments on residential properties and commercial properties. Under the rules that govern the hearings, the commercial properties must be represented by an attorney. So these people are getting advice. They are not fearing retribution of any kind. They're being advised whether they have a good case or a bad case. The concern was about residential property owners. And you should know, anybody can file the appeal. If you're residential, it costs about $33. If you're commercial, no matter what the value of your property, it could be $200 million, you pay $100 to file an appeal. So it doesn't stop anybody from doing that. And again, I'm just giving you two examples. In Denver, which has the highest number of appeals, only 3 appeals were residential that were filed in 2019. Those people can appear pro se. And yes, maybe those 3 might be dissuaded, but it is not any significant number. And even those people have paid their tax ahead of time. So no, this does not. This bill was brought to me by the county assessors, and it is supported, from what last I heard, from every county assessor.
Representative Bockenfeld.
I don't think I got a good answer in there, folks. We want to encourage people that if they do not feel that their property taxes were fairly done, that they can appeal them. By allowing the Board of Assessment to raise those values, you're creating a fear that if they appeal, that someone may try to raise the value on their property in retribution. That's not what we want to accomplish here. We have Board of Assessors who should get the job done the right first time. Not for them to get a second bite at the apple because they want to raise property taxes in a particular county or jurisdiction, depending upon their financial budget in the county or that jurisdiction. So I urge a no vote. Tell the assessors to get the job right the first time. Thank you.
Representative Larson, I'm sorry, is before you, Rep. Arndt. Rep. Larson.
Thank you, Mr. Chairman. So, members, I actually have a question for the bill sponsor here. So the provisions, now if we do go to the Board of Appeals and there is an increase in the assessed value of the appellee, how long, what is the timeline that that appellee has to remit the additional owed taxes, and what mechanism is there? Are there fees, fines assessed, or is it just paying the delta between the original amount paid and what the new amount would be assessed if there is an increase that does result.
Representative Benavides.
Thank you, Mr. Chair. I don't know, honestly, because that is a ALJ decision effectively. It has the effect of that, so they do pay. But again, we are not talking about people that are easily dissuaded. We are talking about commercial property owners represented by attorneys. They have to be. They have to be represented by attorneys under the rules. So they are getting advice. And just like anybody that goes to court, you have the right to get into court for your appeal to be heard. You don't have the right to ensure you're going to be win or no worse off. It's a risk you take, and this is about fairness. And our Board of Assessment Appeals members are supposed to look for the value of the property. And that's what they're attempting to do. And this is, again, about fairness. It is not to hurt anybody or dissuade anybody from filing.
Representative Larson.
Thank you, Madam Chair, and thank you to the bill sponsor for that explanation. So, members, this is an extremely important question to answer, to be frank with you, because unlike a county assessment office where we have a lot of budget constraints, our budgets are made out in the open, there's a certain level of predictability. For a business with a commercial property assessment, if their bill goes up and they have to pay, in some cases, and in many of these larger cases that may end up before this board, millions of additional dollars in taxes on a given year, and if there are penalties and fees assessed on top of it, we're talking about thousands of jobs that could be lost. I don't know how many of you are familiar with a commercial appeal process. I've never gone through one myself, but as someone who's paid commercial property tax rates, commercial property is not assessed in the same way as residential. Residential is fairly easy. You look at comparable sales in the neighborhood. It's basically assessed on the value of the home. Commercial property uses a number of different mechanisms, and it varies from county to county. It's a very complicated process. Some assessors will utilize the revenues that take place that are generated by the businesses that are paying that commercial rate. Some assessors will use the rent that is paid and comparable amounts of rent. The problem with that is, if you have a shopping center that's anchored by, for instance, a major grocery store that has a high amount of traffic, you may have some retail shops that have a really high sales amount. And you may have them with a much higher rental rate because they're paying for that foot traffic. But you might have a office park that sits behind that. And that office park doesn't have any retail, but it's a fundamentally different kind of transaction. Now, most good assessors, frankly, will take into account the differences there, but we have 64 different assessors, and they have different employees, and it can be applied differently. So this is not a simple process. There is, frankly, a lot of discretion given to people who are calculating these values. So I say that to caution that this is not a question, it's not like going in on a residential property tax assessment rate and saying, says my property's worth $400,000, my neighbor sold their house for $380 and his house was bigger than mine. That's a pretty apples to apples comparison, but if it's, hey, this shopping center on this side of the street generated this much revenue, that shopping center on the other side of the street generated twice as much, you can make a case that property is worth more, you can make a case that property is worth less, but again, there's a lot of discretion to it. And the thing that I would caution all members when they're voting on this bill is to think about the potential negative outcome of a business getting a substantially higher assessed rate that they are then having to pay in a very short period of time. Could be months. And if any of you have talked to anyone who runs a business, having tens of thousands, hundreds of thousands, or millions of dollars of additional liability owed to a county that you have to pay over the course of a few months is devastating. So I wouldn't say that it's frankly as simple as, everybody gets their day in court with this one. I appreciate what the assessors are trying to do, and I fully admit that there are people that game this system because they know that they don't have anything to lose by a filing. That happens. It's not a totally unjustified concern. But there are many people that go before these boards that that do feel like they have been unfairly assessed, but would not choose to go through this process if they knew that they could potentially get a higher assessment. And if they did have a higher assessment, the fact that we don't know what timeline they have to pay back, the fact we don't know if there are fees or fines assessed for any taxes that weren't paid, these are million-dollar questions, literally, to some individuals. And I would say that the fact that we don't have certainty on what that timeline looks like, the fact we don't have certainty on whether or not they even exist in the bill, are big problems. So I would encourage you to vote no on this. And thank you.
Representative Arndt.
Thank you, Mr. Chair. If we are fully cognizant and aware that people game the system for their benefit and the system's not fair, then I'm in support of this bill. I heard it in committee. It passed out 10-0. When you go to court to appeal something, if your only options are to win or be neutral, that is not how we do things. I trust the assessor's office but I know humans make mistakes. We have an appeals process. Sometimes your assessed value, not your rate, the rate doesn't change, but your assessed value can change, thereby changing your ultimate bill. But I can't imagine a situation where we have in law that assessors only make mistakes in one direction. That is not logical. It's possible upon appeal that they have made an error in the other direction. That's what happens when you go to appeal to have a reevaluation of the value of your property, and I'm in strong support of this bill.
Representative Holtorf.
Thank you, Mr. Chairman, esteemed colleagues. In February, I went to House District 64 and had a county commissioners roundtable. And I don't know the impact of this on what I'm going to mention, but I'd like the bill sponsor to help me, just so I'm sure that there's not a conflict of interest. Now, the real issue that my county commissioners had in 9 counties, that's 27 county commissioners when I use my cowboy math, they said, we want you to take this message to the state capitol. We want local control of our counties. We county commissioners want to be able to do our jobs as elected officials in running the affairs of our counties. And they're very frustrated with the state of Colorado and the state stepping on their toes and enforcing a one-size-fits-all solution to 64 counties in the state, of which I represent 9. So I want to make sure that those county assessors and the county commissioners and those of the valuation processes are not negatively impacted. And it's not the state trying to put their thumb in some way on the counties, just so I get a better understanding, because I don't know the position that I should have to represent my constituents across 9 counties in southeast Colorado. So I offer that for explanation, Mr. Chairman.
Representative Gray.
Thank you, Mr. Chair, and thank you, Representative Holtorf. The Colorado Constitution requires uniform taxation across the state. So we don't want to call it one size fits all, has a negative connotation, but the Constitution of the state requires uniform property taxation across the state. And so the purpose of this bill doesn't affect that at all. It's about a procedural aspect of delivering in the state, but that has nothing to do with one community versus another. Every county assessor retains their full jurisdiction. It's the county assessors themselves who have asked for this to come forward. But just know that it's not an option that you can have one county assessor treat property dramatically differently than other county assessors. And the reason for that is it's in the Colorado Constitution, and it's something that we all stand for, and we all want to step back, and I can get you the site for that if you like. But uniform taxation across the state is a constitutional requirement in Colorado.
Is there further discussion? Representative Van Winkle.
Thank you, Mr. Chairman. And members, frankly, I was torn in committee on this when I talked to my assessor, and I know she does a very good job and wouldn't go after anyone, but my concern here lies on a couple grounds. Number one, I'm not sure this bill is really necessary because in 2 years, there's another assessment that takes place. So if the assessor during that process finds something brand new about a property that could raise the rates of that property, I know, especially for residential, that impact may be big, but if you're a homeowner that owns a $225,000 house, something like that, for the county, it's not the worst thing in the world that they would have to wait 2 years to implement that tax increase. Whereas if you're that homeowner, that could be very detrimental. I do believe it would have a chilling effect, which I think is one of the reasons we're having this bill, is because our assessors right now are so overwhelmed, especially in the metro areas with home prices skyrocketing the way they are. Taxes and property taxes are also skyrocketing along with the home prices. So I do have some serious concerns with the bill and ask you all to vote your conscience.
Is there any further discussion? Seeing none, the question before us is the passage of House Bill 1083. All those in favor, please say aye. Aye. All opposed, no? No! The ayes have it. House Bill 1083 passes. Mr. Gregorio, please read the title to House Bill 1057.
House Bill 21-1057 by Representatives Roberts and Tipper, also Senators Cook and Rodriguez, concerning prohibition against the extortion of immigrants for engaging in lawful acts.
Representative Roberts.
Thank you, Mr. Chair. I move House Bill 1057. There are no committee reports.
To the bill.
Thank you, Mr. Chair. Members, House Bill 1057 expands on an already existing statute of extortion to protect victims of crime so that they do not feel intimidated or scared of reporting a crime that's been committed against them just because of their immigration status. This bill has support from all 22 elected district attorneys in the state and received no opposition in committee. It's a good bill. A victim is a victim, and we should have our laws reflect that reality. I ask for an aye vote.
Is there any further discussion? Seeing none, the question before us is the adoption of House Bill 1057. All those in favor say aye. Aye. All opposed, no? No. The ayes have it. House Bill 1057 passes. Mr. Gregorio, please read the title to House Bill 1025.
House Bill 21-1025 by Representative Arndt, also Senator Janal, concerning a clarification under the Colorado Open Meetings Law of the requirements governing communication by electric mail that does not relate to the substance of public business.
Representative Arndt.
Thank you, Mr. Chair. I move House Bill 1025.
To the bill.
There is no committee report. Thank you. Members, this is a pretty, really narrow bill that deals with electronic mail. We call it email. And what we're trying to do is clarify in the open meetings law that any email sent between does not constitute a meeting under Colorado open meetings law. This includes email that is just regarding scheduling and availability, sent by an elected official for the purposes of forwarding information, responding to an inquiry from an individual who's not a member of the state or local public body, or posing a question for later discussion by the public body. This is a clarification bill because right now if you hit reply all on one of these issues, some people feel like that constitutes an open meeting, that would need to follow that with the posting and everything else, and that would pretty much grind government to a halt. So with that, I believe we have an amendment.
Representative Williams.
Thank you, Mr. Chair. I'll go ahead and move this amendment and explain it. Mr. Chair, I move L001 and ask that it be displayed.
The amendment is properly before us. Please proceed.
Thank you, Mr. Chair. So, members, when we were hearing this bill, there were a few concerns that I had. I want to commend the bill sponsor for her presentation, her witnesses, because it did alleviate many of the concerns I initially had. But there was one thing with respect to the definition of merits or substance that I just wanted to make sure we got clear so that we're doing everything we can to be open and transparent as government officials. And so what this amendment does, L001, basically defines what we're talking about with merits or substance. And it was a little bit of a challenge because we all know what it is when we see it, but it's sort of hard to articulate. So I want to thank the bill sponsor for working with me to ensure that we get a narrow definition on this. And should this pass, I'll definitely be in support of this bill. So thank you.
Representative Arndt.
Thank you, Mr. Chair, and thank you to my colleague, Representative Williams, because he had that question in committee, and I said, if you'd like to work on some language, please do, and he brought this, and I agreed with it. Doesn't change the intent of the bill, and I'm happy to accept this amendment, and I urge an aye vote.
Is there any further discussion on the amendment? Seeing none, the question before us is the adoption of Amendment L1. All those in favor, please say aye.
Aye.
All opposed, no? The ayes have it. Amendment L1 is adopted. We are back to the bill. Is there any further discussion? Mr. Minority Leader McKeon.
Thank you, Mr. Chair, and thank you, Representative Arndt, for bringing this bill. I have a question, because this is specifically calling out electronic mail communications. The challenge I think that we have is that the world moves very quickly. And so I know that through this period of COVID, especially at the beginning of this, there were several articles written about the lack of transparency. So anytime we kind of head toward, okay, we don't have to worry about this under an open meetings piece, I also worry then, can electronic mail communications, is it a flatly defined term and we know that is an email service? Can it be text messages? Can it be any other kind of service? And I guess I ask that because anytime we do something that says, okay, we want to be able to have casual communications as casual communications. I think that's what this bill says to me. My concern is that when those go beyond that, are we limiting the ability for the public to see what we do?
Representative Arndt.
Thank you very much, Representative McKeon, and that was my question too. This very narrowly defines it as electronic mail, email. We are not touching texting. I think that needs to be addressed, right? The texting, Zooming, those sorts of things. And now we have private messaging, possibilities or messages that all those other things. This bill doesn't seek to address that. That is a much bigger can of worms that I'd be happy to work with you on.
Thank you very much.
Is there any further discussion? Seeing none, the question before us is the passage of House Bill 1025 as amended. All those in favor, please say aye. All opposed, no? Oh. The ayes have it. House Bill 1025 as amended passes. Mr. Gregorio, please read the title of the House Bill 1031.
House Bill 21-1031 by Representatives Doherty and Woog, also Senators Lee and Gardner, concerning continuing jurisdiction to modify family law orders during the pendency of an appeal.
Representative Doherty.
Thank you, Mr. Chair. I move House Bill 1031. There is no committee report.
To the bill.
I'm proud to bring House Bill 1031. The bill passed unanimously in the Judiciary Committee. This provides critical protections for families and children when family circumstances change when a matter is on appeal. It's a direct response to a January 2020 Colorado Supreme Court decision that blocked the exercise of trial court authority to respond to changing family needs.
Representative Woog.
Thank you, Mr. Chair. While we haven't seen the full effect of the court's January 2020 decision, we can certainly draw upon past real-life examples from family law attorneys. For example, the parents of a toddler were awarded 50-50 custody. About 2 months after the permanent orders were issued, the mother discovered that the father was drinking excessively and displaying mental health issues while caring for the child. The mother filed a motion to restrict the father's parenting time and was successful. The permanent orders were modified several times during the following months as the father worked to get his life back on track, and had the mother not been able to modify her parenting time orders, she would not have been able to protect her child from an impaired parent. The fact is, passing this bill could very well save a child's life, or at a minimum, protect a child from physical and psychological abuse. HB 1031 is not without precedent. The General Assembly provided similar authority to trial courts when a juvenile protection order is on appeal. 1031 draws on that language adopted by this body. It restores vital protections for Colorado families and children, and I ask for your support. Thank you.
Is there any further discussion? Seeing none. Seeing none, the question before us is the passage of House Bill 1031. All those in favor, please say aye. Aye. All opposed, no. The ayes have it. House Bill 1031 passes.
That one's the amendment.
We do not applaud Representative Gray. Mr. Gregorio, please read the title of House Bill 1091.
House Bill 21-1091 by Representatives Doherty and Lynch, also Senator Buckner, concerning sentencing parity for juveniles convicted as adults following the transfer of charges with juveniles convicted as adults following the direct filing of charges.
Representative Doherty.
Thank you, Mr. Chair. I move House Bill 1091. There's no committee report, but I do have an amendment.
Your choice on whether you start talking about the bill or whether you move the amendment right away. Representative Doherty.
I'll move Amendment L001, and I ask it to be displayed.
All right, the amendment is properly before us. Please proceed.
Thank you, Mr. Chair. This is a very technical amendment worked on and supported by the Colorado District Attorney's Council and the Colorado Criminal Defense Bar Association. The language we're asking to be removed worked for the direct file statute, but does not work for the transfer statute as addressed in this bill. In the transfer statute, you literally cannot originally file criminal charges by information or indictment into district court, which is why we are seeking a transfer in the case. Therefore, this amendment cleans up the statute so there's no confusion upon a transfer. Thank you.
Further discussion on the amendment. Representative Lynch.
Thank you, Mr. Chair. It's an honor to serve with you.
And also with you.
I'm proud to bring House Bill 1091 to the floor of the House today.
Representative Lynch, excuse me, are you speaking to the amendment or to the bill as a whole?
The bill as a whole. Oh, I support that amendment, by the way.
Oh, very good. Thank you. We'll give you a moment to speak about the bill in just a moment. All right, is there any further discussion on Amendment L1?
No, we ask for your support.
Very good. Seeing no further discussion, the question before us is the passage of Amendment L1. All those in favor, please say aye. Aye. All opposed, no. The ayes have it. Amendment L1 passes. We are back to the bill. Representative Lynch.
Thank you, Mr. Chairman. I'm proud to bring this bill, House Bill 1091, to the floor today. The bill passed unanimously in Judiciary Committee. There was a bunch of stakeholding that went on with this throughout all of the DAs around the state, and we didn't find anything other than this is basically cleaning up some old legislation. Bill's common sense, narrow, and basically just kind of fixes some statute that was overlooked earlier. Thank you, Mr. Chair.
You're welcome. Representative Doherty? No? Okay. Is there any further discussion on House Bill 1091? Representative Sandridge.
Thank you, Mr. Chair. When this bill first came to me, I was severely outraged about the unconstitutional measures that came up, an attack on our democracy and every single person in this state. The cries my constituents rained down about the lack of respect. Okay, actually, it's a pretty good bill, and it does a good job. Actually, I like this bill. There's been actually some Supreme Court. There's been some history on the Supreme Court actually supporting things like this. So especially with juveniles, a lot of research shows that juveniles really need to be placed in the criminal justice system at a lighter sentence, and also it opens it up for when we look at mandatory minimums. I'm a fan of mandatory minimums at time, but when you're looking at juveniles, they need to be treated differently. Even adults up to around 25 years old, especially men. So I think in the long run, this is a great bill, and in the long run, I think it'll save us some money too. So I'm in favor of it. Thank you.
Is there any further discussion? Representative Doherty.
Thank you, and I'm so glad to bring a bill where we are all in support of children. I ask for your support. Thank you.
Is there any further discussion? Seeing none, the question before us is the adoption of House Bill 1091 as amended. All those in favor, please say aye. Aye. All opposed, no. The ayes have it. House Bill 1091 as amended passes. Mr. Gregorio, please read the title to House Bill 1063.
House Bill 1063 by Representative Lantin, also Senator Rodriguez, concerning additional means by which credit for reinsurance may be allowed to a domestic seating insurer.
Representative Lantin.
Thank you, Mr. Chair. I move, hold on a second. Thank you. I move House Bill 1063, and there is no committee report.
To the bill.
Thank you. Members, this is a bill we heard last week in Health and Insurance Committee, and it comes from the Department of Insurance. And just, to kind of give you like a frame of why this is coming. Reinsurance is often a national product. In 2017, the United States, the United Kingdom, and the European Union entered into a series of agreements regarding the regulation of reinsurance. And this bill is to facilitate the state adoption that meets these agreements. And this is the National Association of Insurance Commissioners developed this so that states would have a uniform approach to the regulation of reinsurance. This bill strengthens state regulation of reinsurance companies, protects Colorado policyholders, and reduces uncertainty faced by insurers in Colorado when planning for collateral liability. And I ask for an aye vote.
Representative Baisley.
Thank you, Mr. Chairman. So if we do not vote for this bill, if we do not give the authority for Colorado's insurance commissioner to set up our rules for that, then it would revert over to the federal rules that would apply to all states who do not take this step. I frankly am more trusting of the federal government in this one case than our own local insurance commissioner. So I was a no vote in committee, and I'll be a no vote now. But this is not a real big deal to me, but just thought I'd share why I'm a no vote in committee. And all towards, I think the government should have less and less involvement in our health care, not more and more. But yeah, we're kind of forced into this decision. So that's my thinking. Thank you for listening. Thank you, Mr. Chairman.
Representative Lantin.
Thank you, Mr. Chair. I just want to reiterate, this has nothing to do with health insurance. This has nothing to do with our state reinsurance program. Nothing, not even a little bit. This reinsurance is the reinsurance purchased by insurance companies. We will be subject to federal preemption if we don't pass this bill. I think it would be better for us to do that for ourselves. Again, I ask for your support.
Is there any further discussion? Seeing none, the question before us is the passage of House Bill 1063. All those in favor, please say aye. Aye. All those opposed, say no. No. The ayes have it. House Bill 1063 passes. Majority Leader Escar.
Thank you, Mr. Chair. I move to lay over House Bill 1045 to Tuesday, March 2nd.
Seeing no objection, House Bill 1045 will be laid over as requested by the Majority Leader. Mr. Gregorio, please read the title to House Bill 1022.
House Bill 1022 by Representative Froelich, also Senator Janal, concerning the protection of parties through the enforcement of proper surrogate agreements.
Representative Froelich.
Thank you, Mr. Chair. It is a pleasure to serve with you.
And also with you.
Folks, this bill, let me move. Got to get back in the practice. I move House Bill 1022 and the Health and Insurance Committee report.
To the committee report.
Thank you. The committee passed an amendment and otherwise was delighted to pass the bill onto the cow.
Is there further discussion on the amendment? I'm sorry, on the committee report? Seeing none, the question before us is the adoption of the Health and Insurance Committee report. All those in favor, please say aye. Aye. All opposed, no. The ayes have it, and the committee report is adopted. To the bill, Representative Froelich.
Thank you. Members, this bill is concerning surrogacy, and surrogacy is a common way for folks to form families, and it is one of the answers to infertility, among other things. And 1 in 8 people and families suffer from infertility. So this is a chance to protect all the parties involved, the surrogates and the intended parents. And I do have an amendment that I would like to move. Is that okay? I move Amendment L004 and ask that it be displayed. I want to thank...
One moment, please, Rep. Froelich.
I want to thank Representative McCormick for bringing this to our attention. We had some gendered language in the bill, and Representative McCormick asked questions about it, and I thought that they were referring to existing law, and they weren't. And so we are striking the gendered language in the bill and replacing it with the word individual, which I think is appropriate. So I ask for passage of Amendment L004.
Is there any further discussion on Amendment L4? Seeing none, the question before us is the passage of Amendment L4. All those in favor, please say aye. Aye. All opposed, no. The ayes have it. Amendment L4 is adopted. We are back to the bill. Representative Froelich.
Thank you. We think this is a terrific bill. It protects all folks involved in surrogacy agreements. It's supported by the Women's Bar Association, by reproductive organizations that are tackling infertility, and I ask for a yes vote, an aye.
Is there further discussion on House Bill 1022? Representative Baisley.
Thank you, Mr. Chairman, and thank you, Representative Froelich. So this bill touches some really sensitive areas, obviously, for everyone. But what this bill does is it codifies the maturity of putting together families through surrogate pregnancies. It can be done in a real messy way where there's a lot of legal things, a lot of real stress on families this is their only opportunity to have children. But if it's done well, then of course things can be pretty darn wonderful and folks get their babies that they crave. This, in my estimation, is the proper role of state government having interest in trying to make sure that our children have the good home, that they are not fought over inappropriately. This process has been matured by the clinics that do this well over a lot of years, a lot of trials, and this brings in some requirements for legal representation in both the surrogate mom and the parents who are going to receive the child. They both get that representation required in this. So this seems to me to be real wisdom being brought forward, and I appreciate Representative Froelich's bringing this forward. The amendment that just passed makes this it allays the concerns that I did have, so I appreciate everybody passing that amendment. I will be a yes vote, and I would encourage a yes vote from this body. Thank you.
Representative Tipper.
Thank you, Mr. Chair. I honestly just wanted to offer my sincere gratitude to Representative Froelich and the members of the chamber diving in on a topic that perhaps people are not, themselves intimately familiar with, but one that's close to my heart. Just to have the opportunity to meet surrogates is to meet incredible people, the work that they do, the gift that they give to families. And I'll tell you that when my little girl was born, and as some of you know, she is a member of my family because we used IVF and it was successful. And when she was born in the hospital, one of the nurses that we had, we were talking. Obviously, you spend a lot of time after you have a baby, particularly a C-section. I did not know that, in the hospital. And the nurse was telling me that she, in addition to being a neonatal nurse, she was a surrogate. And it was a really incredible story, talked about why she did this work, the mission that she felt. And it sort of felt like this incredible divine intervention to be sitting in the hospital with this brand new healthy baby that we were able to have, meeting a nurse dedicated her life to this career, and then separately in her personal role, serving as a surrogate. So this bill, I am very thankful for personally. I know that you did a tremendous amount of work over the last 2 years getting all the stakeholders together, and Colorado is going to lead the nation in this, so thank you for your work.
Is there any further discussion? Seeing none, the question before us is the passage of House Bill 1022 as amended. All those in favor, please say aye. All opposed, no. The ayes have it. House Bill 1022 as amended passes. Majority Leader Escar.
Thank you, Mr. Chair. I move the committee rise and report.
You have heard the motion. Seeing no objection, the committee will rise and report.
The House will come to order. Mr. Gregorio, please read the report of the Committee of the Whole.
Mr. Speaker, your Committee of the Whole begs leave to report it as under consideration the following attached bills, being the second reading thereof, and makes the following recommendations thereon. House Bill 1022 is amended. House Bill 1025 is amended. House Bill 1031, House Bill 1057, House Bill 1063, House Bill 1083, House Bill 1091 is amended, passed on second reading in order, engrossed and placed on the calendar for third reading and final passage. House Bill 1045 laid over until 3/2/21 and retaining their place on the calendar.
Representative Kennedy. Thank you, Representative Kennedy. There are no amendments at the desk. The question before us is the adoption of the report of the Committee of the Whole. Mr. Gregorio, please open the machine and members proceed to vote. Representative Ricks. All right, my machine up here is not working, so the speaker votes aye. Please close the machine. With 41 aye votes, 23 no votes, and 1 excused, the report is adopted. Are there any further announcements or introductions? Seeing none, Madam Majority Leader.
Members, listen up. Legislative Legal Services has asked me to once again remind you about the delivery of bills for tomorrow's introduction deadline. Your finalized bills will be delivered to the front desk for introduction unless you ask them to deliver the bill to you instead. If you actually wish to have the bill delivered to you, you must have that bill completely finalized with your drafter by 5 p.m. today. If your bill is delivered to you, don't forget to turn it in to the House front desk no later than 4:30 tomorrow. In addition, once a bill is delivered to the front desk or to you for introduction, it should not be returned to Legal Services for any reason. If the bill needs changes, please make those changes by amendment after introduction. If you want to add sponsors, the House front desk or enrolling room staff can add sponsors before your bill is sent to the printer. If you have questions about adding sponsors, please contact the front desk. The legal services staff thanks you. And with that, Mr. Speaker, I move that the House stand in recess until later today.
Seeing no objection, the House will stand in recess until later today.